evening. Thank you for tuning in to the Injustice Anywhere radio program. My name is Bruce Fisher. I'm the Executive Director of Injustice Anywhere. We are an all-volunteer organization working to correct wrongful convictions. We now have developed a network of websites all working to bring more attention to wrongful convictions. You can find those websites on our main website, injustice-anywhere.org. You can also Google Injustice Anywhere, and you can see our main website right there at the top of the page. We currently have 8 featured cases. Those cases are detailed on our homepage. When visiting, you will find links to Facebook and Twitter. Please like us on Facebook and follow us on Twitter in order to keep up to date with current events. Tonight, we will be discussing the Jeffrey Havard case with attorney Jen Fitzgerald and advocate Lori Howard. Jennifer Fitzgerald is a criminal defense attorney in Rhode Island. She's also a member of the Injustice Anywhere Advisory Board. Jen has studied Jeff's case for several years, and she's an outstanding attorney. I'm happy to have her back. She's a repeat guest on the show. In our second half of the show, we hope to have Jeff on as well. We will see if we can make that happen. Those things can be a little tricky sometimes dealing with the phone system. Jeff Havard currently sits wrongfully convicted on death row in Mississippi for the sexual assault and murder of his girlfriend's 6-month-old daughter, Chloe Britt. The truth is the infant slipped from Jeffrey's arms while lifting her from the tub, causing her head to hit the toilet. New expert evidence supports Jeff's claims. Chloe's death was a tragic accident, not a murder. Jeff's defense team recently filed a rebuttal citing a Brady violation. A new affidavit from the prosecution's only expert witness, Dr. Stephen Hayne, strongly supports the defense argument that a Brady violation did occur. We will discuss this new development tonight. I would now like to introduce tonight's guest. Hi, Jen. Welcome to the show.
Hey, Bruce. Thanks for having me.
Great to have you back. Now, before we get started, there's a lot to talk about tonight with the new legal aspects of the case, the new developments. But I'd like to ask you, because I know you just had a chance to visit Jeff, how's he holding up? Is he optimistic about recent events?
He is. Yes, I did go down to see Jeff last week. Flew down to Mississippi, and he's real hopeful. I got a good about 3.5 hours with him, and I'd seen him about a year ago, and while he's always a very optimistic guy, he just with the filing of the new motion that was filed a couple of months ago, I think he just sort of feels like he's finally, things are starting to make sense, and he's finally, his case is being heard, and so that was good to see him like that.
That's good to hear. What's the situation like for visiting a death row inmate in Mississippi? How is that set up?
Well, Parchman is it's a huge place, and it's out in the middle of literally nowhere. The death row is, each unit is sort of separated. I think they're their own little buildings. And, there's real strict security, and they bring you on a bus to take you out to where the inmates are. And he's behind a really thick glass partition, so it's not like a contact visit where you can't shake hands or give him a hug or say hi that way. But there's a phone where, he can talk to you through the glass, and you get usually about 2 hours. I got about 3.5 because I traveled so far, but visits are every 2 weeks, and that's about it. That's about all the contact that they get.
Okay, so it's great that you were able to see him. It's also good to hear that his spirits are up with this new news.
Definitely.
I'm often asked about his current appeal status. Can you explain to our listeners what stage of the appeals process Jeff is currently in?
Sure. Jeff was tried for murder committed during the course of a sexual assault, and that happened in 2002, and he was convicted and sentenced to death. He filed for a direct appeal. Then he had filed 2 post-conviction motions, which are all, for layman's purposes, I guess, they're all just what everybody considers to be an appeal. Was there an error in the case? Is there any new kind of evidence that wasn't considered by the jury? And all of his state appeals had been denied, and so he had filed a habeas corpus petition in federal court, and that is actually still pending. And while that has been pending, the defense had found some newly discovered evidence, stuff that didn't exist at the time of trial or that they didn't know about at the time of trial. and you have to go through the state system first. So they had to go. We are now back in state court. And the pending motion in state court deals with the fact that Jeff was convicted of having shaken this child to death. And there's now all kinds of new science that really suggests that scientists, what they once believed is not really the case anymore. They know that their logic and scientific reasoning was not correct. So there's evidence that he actually is innocent of having shaken the child to death. And while that has been pending, actually through a newspaper article, there were some statements that were disclosed to Jerry Mitchell, who is a fantastic journalist with the Clarion Ledger, and he published some of those statements that were made by some of the state's witnesses, or one of the state's witnesses, and the defense immediately took a look, and it turns out that it appears the prosecution really suppressed, didn't turn over to the defense evidence that they absolutely should have, evidence that definitely points to his innocence, that shows he's actually innocent. And so his attorneys in this case are at this point raising that in the state court. Does that make any sense?
So it's currently in the state court. In the federal court, they're holding off, waiting to see how the state responds to this current motion, this current filing.
Correct. They've sort of hit pause in the federal court. They've stayed everything until we can find out what happens down in the state court.
Yeah, I think there's a little confusion when people are trying to follow the case because people believe that it did go to the federal level. So I just wanted to clear that up on why it is still pending in the state level. It is because there's new evidence that needs to be looked at.
It's actually stopped in the state. We were done in the state court, up in the federal court, and then we found new things, new evidence, and you can't raise it for the first time in federal court. You've got to go back down to the state court. So that's where we're at right now.
Excellent. Now let's discuss this recent rebuttal that was filed by Jeff's defense team. First off, I want to discuss the fact that this was already previously filed based on an article written by Jerry Mitchell in the Clarion Ledger. What was the state's reasoning for rejecting that argument a few months back?
Well, actually what had happened is Jerry Mitchell published an article on January 19th of this year. And as I just said, there were some statements made by the state's witness. The particular witness was their sole expert witness. I think there was one other expert that testified about, crime scene analysis. But the real expert in the case, Dr. Stephen Hayne, who's somewhat of a controversial figure in Mississippi at this point, but he had made some statements to Jerry Mitchell that he actually has never believed that the child in this case was sexually assaulted, which is the sexual assault in this case is what made Jeff eligible to receive the death penalty. Because as I said earlier, it was murder during the course of a sexual assault. And Dr. Hayne was the expert pathologist that had performed the autopsy in this case. He had drafted an autopsy report, and he hadn't mentioned anything about sexual assault in his autopsy report. He testified at trial that he didn't. Well, let me back up a little bit. The defense filed basically a motion to amend or to add to the motion that we already had in state court. And what they wanted to add is the prosecution has known of what's called exculpatory evidence that's favorable to Jeff's side of the case. And they've known it basically all along, that Dr. Hayne truly didn't hold the opinion that supported the state's theory of the case, and that they failed to tell the defense that. So that motion has been filed because that's new evidence. We've never known that to the extent that we do now. And the state is entitled to reply to that in writing. So they had replied. And their reply really, that was from a few months ago, what you had just mentioned. Their reply really had a lot of legalities about timing and procedural requirements of filing and whether or not, we're out of time or there's some type of procedural bar that we can't raise this now. And then we just recently, last week, filed what's called a rebuttal, and where we address some of the issues that they raised in their reply. And if you want,
they had an issue with the fact that Stephen Hayne's statements were only heard in a newspaper. Was that part of their issue?
Correct.
So now the defense went out and they obtained another affidavit from Dr. Stephen Hayne, to support their argument. And what did Dr. Stephen Hayne say in that most recent affidavit?
The most recent affidavit basically swears to the truth of everything that he told Jerry Mitchell in the newspaper article. And the things that he told Jerry Mitchell in the newspaper article were, I didn't think that there was a sexual assault in this case. He also said he did not, and this is a direct quote, I did not see any evidence of sexual assault. He also revealed, and what I think is critically important, is that he had conducted, he had taken some tissue samples from the child's, some anal tissues, and he had looked at those tissues under a microscope, and he had determined that there was absolutely no evidence of bleeding into the tissues. There was just no injury. And this is a case where Jeff was convicted at trial because the allegation was that there were, when the child was brought to the emergency room for the head injury, that the doctors and nurses were working on the head injury, and they went to take her rectal temperature. And when they did that, one of the nurses noticed that the child's anus was dilated. And that nurse then alerted the doctors, and they had all immediately assumed that the child had been sexually assaulted. And there had never been any previous, allegations of that. The only evidence of sexual assault sort of arose when the doctors and nurses deduced that, theory. They immediately called the police, and the police came in, and that's sort of how the ball got rolling. When Dr. Hayne performed his autopsy report and he didn't find any evidence of sexual assault, unfortunately, he didn't write that in his autopsy report. He merely wrote that the cause of death was shaken baby and that he had found a 1 centimeter contusion or bruise to a portion of the child's anus, which is admittedly not evidence of sexual assault. It could have happened from, a thermometer or passing a hard stool or something like that. He just didn't mention in his autopsy report that there were any tears or rips. When he testified at trial, go ahead. Exactly.
He left it vague.
He just didn't include that in there, right? When he testified at trial, he was called to testify as the state's expert witness. He was basically the most knowledgeable person about, such things as sexual assault. He had done the autopsy report, and he testified in a way that supported the state's case. The state asked him, showed him a picture of the child's anus on autopsy and said, what is this indicative of to you? And he said, it's consistent with penetration of the rectum by an object, which is exactly what the state was alleging. The doctors and nurses were all individually called to the witness stand, and they each individually testified that there were all kinds of rips and tears, and that this was just the most horrific thing that they had ever seen. And they testified that it was, it meant sexual assault. None of those
the most damning information in court was heard by the ER staff. It was not heard by the only expert witness that took the stand.
Well, that's up for debate, because the only expert, the doctors and nurses were not experts. There was no information about what their qualifications were, how many times they'd ever treated an infant for sexual assault, or if they'd ever even given a rape kit before. There was none of that testimony because they weren't supposed to testify as experts. They weren't qualified to make a determination as to whether this child had been sexually assaulted. It's a real specific type of diagnosis.
That's what experts are for. I mean, that's why they testify.
Exactly. Unfortunately, when they started giving opinions on the stand, the defense attorneys did not object to it. Dr. Hayne took the stand, and rather than testifying that I didn't see any evidence of sexual assault, I disagree with the doctors and nurses, Dr. Hayne testified mostly about the head injury, but he also, when he was asked, what is this indicative of? What is this child's anus, this picture I'm showing you, what is it indicative of? He said that it was indicative of penetration by an object. Now, it was also indicative of a whole host of other things, But he didn't offer that. He offered a single explanation, and it just happened to be the one that fit the state's theory of the case.
Right.
So he testified to that, and he also testified, and which I think is pretty important, that on cross-examination, he said he didn't see any tears, he didn't see any rips. He testified that the child was in full rigor mortis when he got the body and he was doing the autopsy, and that he could have, because rigor mortis causes muscles to contract, and that was his testimony on the stand, he could have missed a tear that the doctors and nurses had seen when he was doing the autopsy. We now know from the Clarion Ledger and the statements that he made to the Clarion Ledger that he performed microscopic tissue analysis on all the tissue throughout the entire anal region, that he looked at them under a microscope, that it was, as he put it, definitive that there were no rips or tears to the child's anus. And quite frankly, with no other evidence of sexual abuse, there was no semen, there was no DNA from Jeff, there was nothing. There was never even an original complaint where somebody said, I think my daughter or my friend's child is being abused. It was based solely on what they observed. So in a case like that, Dr. Hayne knows that the doctors and nurses had to have been mistaken. They had to have, and it's very easily mistaken in that kind of a situation.
Sure. That's why there's an expert that should clarify these things. His statement in his current affidavit is very clear. He says, prior to trial and before taking the witness stand at trial, I informed the prosecutor, Ronnie Harper, and members of his office that I could not support a finding of sexual abuse in this case.
Correct.
So how did they possibly pull this off in court? Can you please explain to our listeners, as a defense attorney yourself, why his defense might have shied away from asking the prosecution's expert outright if he felt a sexual assault had taken place? Why was there no cross-examination? Why did they have that fear? Well,
I think that, first of all, Jeff's trial from start to finish was a day and a half. So if you want to include jury selection, you're looking at 2 days maybe. So there wasn't a lot of extensive questioning going on, and the defense attorneys didn't even cross-examine one of the doctors. But in this particular case, there's always, when the prosecution puts on their key witness, the one that did the autopsy and has the most knowledge about what caused the child's death and what caused any injuries that existed at the time she died. And in a case where the single most important fact is whether or not she was sexually assaulted, because that's what gets you the death penalty, and if there's no sexual assault, then they've mischarged it. Then if he's innocent of sexual assault, then you're in there on the wrong charge. And
sure.
If any at all, that should be charged. And so when you put that guy on the stand and the state's attorney doesn't ask the doctor, did you come to a conclusion? Was this child sexually assaulted? That is sort of a red flag normally, that what's going on here? Why wouldn't you ask this one guy who's really the only one that's qualified to give an opinion there what his opinion was? Well, the defense had been given a report that it was authored by the chief sheriff investigator in the case. And the defense was given that report during the regular course of discovery, and it said in the report that Dr. Hayne had called the sheriff the night that he did the autopsy, which was the night after the child died, and he gave a verbal account of his preliminary findings. And the preliminary findings were shaken baby syndrome, and that he had concluded that both the child's anus and her mouth had, quote, positively been invaded by some foreign object causing trauma and damage. And that was just part of the report. Now, the state has never corrected that. The state's never given, I don't know that they've ever even been questioned on that. But the defense was clearly under the impression that this guy, who is the state's most important witness, believes this child was positively sexually assaulted. And they're not going to, at least I wouldn't, ask him to, are you sure? What's your opinion on this? If the most he testifies at trial is that it was consistent with a sexual assault, because the defense was not allowed to have their own witness.
Defense was, because his defense was clearly incompetent. We won't get into that tonight. We've talked about it in previous shows. But there's a reason why a defense attorney doesn't ask a question about sexual assault to an expert on the stand that they believes a sexual assault took place. So
absolutely
here
not.
we get to the Brady violation. The information was kept from the defense so they could not properly cross-examine the only witness that was an expert in this case. So let's talk about this Brady violation that was brought up in the most recent filing that I believe is just the blockbuster news in this case that we've been waiting for. I hope that others feel the same way. But let's discuss that now. What does that entail?
Well, there's a case, Brady v. Maryland. It's a Supreme Court decision that's been around for years that says that when the state has evidence that's favorable to the defense, that they have to turn that over to the defense. The defense doesn't even have to ask for it. If the prosecutor learns of something that points to innocence or that impeaches the credibility of an adverse witness that's adverse to the defense, they got to tell you about it. And even if you have the worst defense attorney in the world just sitting there doing nothing, the state has to tell you. And in this case, the prosecutor, at the time of trial, before trial, at the time that this case was charged, he knew that his main witness did not believe the child was sexually assaulted. Dr. Hayne has come forward and he's been very clear. I did not think that there was a sexual assault in this case. The fact that the state didn't turn that over to the defense and that they went through this trial, sort of fudging their way, for lack of a better way to put it, and suggesting, everybody in that courtroom believed that Dr. Hayne thought that this child was sexually assaulted. Perhaps it's because the prosecutor stood up at the opening statement and said, Dr. Hayne's going to come in here and he's going to testify for all of you that he confirmed the doctors' and nurses' worst fears, that this child was shaken and sexually assaulted. And the defense didn't object to that as being, not part of the evidence, because that's the impression they were under. So first you've got that Dr. Hayne...
And that was right at the beginning, opening arguments. He said to the jury what Dr. Hayne was going to say.
Correct. And Dr. Hayne took the stand, and although he didn't say, this child was sexually assaulted, in the middle of the direct examination, the prosecutor Harper, when he showed him the picture of the child's anus and, what is that and what does it indicate to you, and when he offered up, it's penetration of the rectum by an object, that prosecutor Harper at that point literally just switched directions and said, okay, now I didn't mean to interrupt you. We were going over some of these other pictures, and then never came back to the topic. So what they did is they essentially in their closing stood up and said, you heard all the witnesses. Every single one of our witnesses told you what happened. Every single one of our witnesses. And they said, there ain't no other way that this could have happened except for Jeff Havard committed a sexual assault. The problem is the prosecutor knew there was another way, because if Dr. Hayne can't conclude that a sexual assault happened, if he doesn't see any evidence of it, then of course there's another way that it can happen, because another way that it can happen if there are even any physical damages or physical injuries, which, as it turns out, Dr. Hayne was well aware that there weren't any. So you had this speculation from the doctors and nurses who all were trying to save this kid from a head injury, and they were working on the head injury. They had this, the child, I don't know how to describe this, without getting really too technical, but they didn't have a very good view of the child's anal tissue, with all the secretions and so forth. And so they thought they saw some sort of a tear. Now there was no blood, okay? There's no blood isn't mentioned in any of the hospital records or anything like that. And so they mistook, something for a tear. When you send something to autopsy, and the pathologist takes a look at, the body, and he confirms or disaffirms, maybe what the doctors and nurses suspected was either the cause of death or the cause of injury. And Dr. Hayne's tissue analysis definitively shows, there simply were no tears. the defense was not entitled, says the court, to its own independent expert. They had never had one during trial, so they were stuck with whatever Dr. Hayne said. And the defense on their appeal found this doctor, Dr. Lauridsen, who had agreed to take a look at all of the physical evidence and to render,
this is during post-conviction relief, correct? This
during
is after conviction.
Correct. So he's tried and convicted, and finally he gets the expert that he's been asking for since the beginning. And he was not allowed to use that expert on his direct appeal for legally complicated reasons that's not important here. But he had to wait basically until 2007 before really his own independent expert could take a look at these tissue slides himself. Now, keep in mind, the defense has no idea that Dr. Hayne is of this opinion. Dr. Lauridsen takes a look at them, and he finds, through his tissue analysis that there's absolutely no evidence of rips or tears or any injury at all. And in a case, as I said, where there's no allegation, it's all just based on what the doctors and nurses saw. If there's no rips or tears, there's no sexual assault, period. Well, the state, unbelievably, argued that Dr. Lauridsen wasn't there in the emergency room, and Dr. Lauridsen didn't actually examine the actual child live, that he had looked at some photographs and he had looked at the records, and that his report and conclusion was vague, speculative, and questionable. And
even though he looked at the slides.
Even though he looked at the slides, okay? And by the way, I should point out that it took about 6 months of back and forth of filing motions and the court ordering the state, look, turn over these tissue slides. The state just sort of, dilly-dallied and found excuses for why they couldn't turn them over, and then when they finally did turn them over, they were defective. We had to send them back. We didn't even get the tissue slides until after the deadline had been filed. So for some reason, it would seem that the state really didn't want Dr. Lauridsen to have a very good look at these tissue slides, and now we know why. But the problem is that not only have you got prosecutors at trial sort of, fudging their way around, putting a witness on the stand and sort of artfully dancing around, asking the question of what his real opinion is, so nobody ever finds it out. On appeal, the state filed their objection and, that we shouldn't overturn the conviction, and they criticized Dr. Lauridsen's findings when they knew all along, and we didn't, that Dr. Hayne looked at the same tissue samples and that he came to the same conclusion that Dr. Lauridsen had. So they're arguing that Dr. Lauridsen just that opinion's not worth anything. And all the while, they knew before trial that their own expert had come to the same conclusion, and that's why. Because
Dr. Hayne had told them before trial that he saw no evidence of a sexual assault. So now they've heard it from two experts.
Well, they've heard it from two experts, and the issue is that they've heard it from two experts, and they've heard no experts say that this was a sexual assault, because the doctors and nurses.
Now the bottom line is, for average people like me looking at the case. Right. If that information was not withheld by the prosecution and the defense knew that Dr. Hayne saw no evidence of a sexual assault, they could have asked one question in court and blown this case apart. They could have looked at him and said, did you see any evidence of a sexual assault? And based on what he said before trial, his answer would have been no. Absolutely.
And what's really key here is that Dr. Hayne didn't reveal that, and that's misleading, okay? There's no way that it's not misleading, and I don't know whose fault it was, but the prosecutor couldn't have possibly thought that it had been communicated to the jury that Dr. Hayne saw no evidence of sexual assault. I certainly hope not, because they stood up in their closing and argued that every one of their witnesses testified that there was a sexual assault here. And the situation is that had the defense known that Dr. Hayne had conducted this tissue analysis, which is not mentioned in the autopsy report, had they known that, it would have eliminated, it would have destroyed all of the testimony of the doctors and nurses, because quite frankly, it's simply impossible to have a rip or a tear that you see with your naked eye, that when you review the tissue samples microscopically, there's no blood, there's no rip or tear or injury to the skin, and that's pretty much what the purpose of a microscopic examination is, to magnify it and to see what really was going on here. So there would not have been any testimony from the doctors and nurses had the defense, known this. And it's important also to point out that the prosecutor faults the defense. The prosecutor is saying, look, you never went and spoke to Dr. Hayne before trial. You never asked him any questions. If he had just done that, you would have learned what his true opinion was. When the bottom line is that Dr. Hayne, since the time of trial, Jeff's current attorneys have gone out, they've gotten three declarations from him. Dr. Hayne was subject to a deposition in 2010 where he gave, each step of the way he's giving a little bit more information, but we're just finding out in 2014 that in 2002 he had definitive proof that.
Right. Well, Dr. Hayne, we can't get into it tonight because it's a whole other show. But he's a shady guy. He's been investigated now in several cases in Mississippi, and we've seen time and time again that he testified in favor of the prosecution. He was stacking autopsies. He's not a good guy. But the truth is, if the prosecution wouldn't have withheld what he said, this whole case would never have gone the way it did.
But regardless of what Dr. Hayne's reputation is, regardless of whether or not somebody wants to say, he's just making that up now, he's mad at the state, or for whatever reason, the bottom line is that we've got tissue blocks, and we've had 2 doctors look at them. And what Hayne is saying is absolutely true. There's no evidence of sexual assault. So whether or not he told the prosecutor before trial, Jerry Mitchell also called up the prosecutor. And the prosecutor said that he knew going into trial that Dr. Hayne was his weakest witness. Well, what do you mean? He's your expert. And no weakness was disclosed to the defense. If there's a weakness, you've got to tell the defense about it. And the bottom line is the jury was told this is a slam-dunk case. It appeared to be a slam-dunk case, when literally the state knew that this simply could not have happened.
With the whole situation, the jury was kind of handcuffed. They had no other information other than what the prosecution was telling them, so this certainly doesn't fall on them.
I have Jeff actually on the phone. He's calling through right now.
If we do have a little delay trying to get this call through, please bear with us. It's a little tricky connecting with Jeff's phone, but we will get it done. We will be taking calls as well. Please call 347-850-1478 with any questions or comments. We'll take calls from now until the end of the show.
All right, I've got him on the phone, and I'm going to transfer him now.
So if anybody has a question or comment for Jeff, he'd be happy to answer it for you. And, of course, Jen is here to answer questions as well. I'm also going to bring Lori on the line. Hi, Lori. Are you on the air?
Yeah, I'm here.
Hi, Lori.
Sorry,
how are you doing?
Late. Fine.
No
Thank you
problem.
for having me back.
We'll bring you in for the conversation with Jeff.
Sure, that'd be great.
Oh, here we go.
Jeff, are you there?
Hi, Jeff. How you doing?
How are you? I'm okay. Thanks for having me.
If you could speak up a little bit, we could hardly hear you.
Okay. I'm doing okay. How are you? Thanks for having me.
Oh, good. Well, you should be in a good mood. I see Boston got a win yesterday. Those are hard to come by for that team this year.
Finally, right?
They finally pulled one off.
Right. Well, they'll wind up making history again, worst to first, and looks like worst again this year. But
I like to hear optimism.
Well, I mean, hey, I can't complain. There's a series, a championship, so I can't.
Well, we have a lot of things to be hopeful for now. How are your feelings about recent events in your case? Are you optimistic about this recent rebuttal?
Yeah, absolutely. I'm optimistic, but it's kind of a bittersweet validation, so to speak, because nothing's changed yet, but still it finally it's come to it. It seemed like it's taken a half a generation to get something out that should have been out from the very beginning, and it's, so it's kind of it's nice, it's validation, but it's still bittersweet because we're still got to wait. So
it has to be incredibly frustrating to take this long. We've seen this time and time again in cases. The conviction takes a couple days, and correcting it takes decades. So hopefully something very good comes out of this.
And I hope so. I'm hopeful. I'm as hopeful as you can be, and it's in a good place. It's just it's not out of the woods yet, of course, but still, I guess the feeling would be cautious optimism.
It's a good thing to be. I mean, you have to be cautious, but for me, this is this is the most positive information I've seen since we've been following the case. Well, like you said, you have to be cautiously optimistic.
Absolutely. I mean, the way that it's being litigated in the appeals, it's all these years it's been, this guy's confirmed this. Talking about the pathologist here, he's confirmed this over all these years. That's been their, that's been their disposition or their posture in the case, and. Now,
we haven't actually told them that yet, Jeff, so if you want to tell them about, I think, 17 different times and all throughout the...
Oh, yeah. Well, yeah, I mean, every time, I come up for an appeal and they come in with a response, speaking of the state, every time they come in with a response or a reply to anything that we file, it's this guy, the ME, it's a confirmation by him, he concluded this, and now that it's come out that he positively did not see any evidence of that, and to overcome the new evidence part of things in the appeals to say, well, no, it's he's always had that opinion. It's not new evidence. So somewhere somebody hasn't been telling the truth, or it hasn't. You can't have both. Either he felt this way all along, or you knew all along that he didn't feel this way. So they're kind of they can't have a dual defense to this. It's got to be one.
Can't have it both ways.
Right.
Right.
Now, have you been in good contact with your attorneys? Have they been able to keep you up to speed with the filing? Have you been able to be active with that?
Oh, I've been pretty active in it, and I've given a lot of my input to it, not necessarily on the authority, the case law, not as much in that, but just in making sure that pertinent facts, irrefutable facts, and basically trying to take the concessions from the state that I've had all along and trying to make them stand by that, and making sure that we point it back out. For instance, how it was laid out. That this guy's going to come in the opening statements and previewing his medical examiner's findings and facts previewing them in such a way that they knew not to be true, and then giving a closing argument. Saying, taking the entire burden of the case, and that's what happened. That's what essentially the case came down to in the directed verdict, that, the burden was totally put upon me to explain this dilation, which is the whole case in chief. And, all along, getting me to explain something that I had no clue how to explain or, anything like that. So, and then to tell the jury, nothing else explains that but that he did this. And all along knowing that the one person solely responsible for explaining that didn't feel it was that. And, apparently it was classified information from me and everybody else except for the prosecution. So, I mean, it's very frustrating, and it's my anger is, I try to channel it into trying to make my case and trying to make my point. And it's just frustrating because, it seems that the people that are opposing me on this appeal, the state, it seems to not be, a pursuit of justice. It seems to be just, defending the convictions as they come in, and that's just my opinion, and that's, don't hold that as gospel for me, but that's just, that is, I've been through this for a half a generation almost. So, and it's very frustrating, and here we are.
We have a couple of calls on hold that would like to talk to you, so I want to go to those because they're calling in to ask you questions. I could be a little more bold about it and just outright say the prosecution stood up in court, looked at the jury, and told outright lies. They knew exactly what they were doing, and they did it. They lied.
Yeah,
if they were on the stand under oath, they wouldn't have been able to do that. But they weren't under oath. They were standing in court, and they lied. We have a call here. It's an 814 area code. You're on the air. Do you have a question or comment for Jeff?
Hi, I have a comment. My name's Vicki, and I'm actually calling from the state of Pennsylvania. And my comment is just to Jeffrey. Jeffrey, I've been following your case for the last year or so. I've actually written a couple letters to you. I just want you to know that we believe in your innocence. We're supporting you. I am just amazed at your strength through all this, just through everything. And just want you to know that our thoughts and prayers are with you. And just hope this turns out and things are right. So that's all.
Thank you so much for the call.
Sure.
Wow. I mean, that's what, that right there, that it's complete strangers, people that don't know me, and I don't know them. It's just that right there. That's what keeps me going. On top of having a good family and good support family and friends and really other people closer to me, and that right there, that makes a difference. And that it's like I said in the beginning, the validation that right there, that I'm at a loss for words. I can't even describe how that it makes me happy that people are actually seeing it. And this was my goal when I started. Bruce, when I first started, and everybody that's listening, when I knew that I had to become vocal and say something, but the facts of my case and the circumstances of it and the very sensitive nature of that, that was a hard, it wasn't a hard decision to do because I knew I had to do what was right and right by Chloe's family and for justice and overall, but that was a hard thing because I knew that sensitive things would have to be brought out, and because of what the nature is of the sensitiveness of the charge itself. And fundamentally
sure.
what it's built upon, and so that was a hard thing, knowing that I was going to take this real sensitive thing, and it's like it's a tightrope you have to walk with that, and it's never been about. I've always wanted the utmost respect and calm and reason and wanted in the discussion, and nothing more than that, and nothing short of that, and. To hear how people respond to it, and just like the lady from Pennsylvania just called, it makes it that helps me go on the next day, and
you always do a great job of presenting your case. We have a couple more calls, so I'd like to get to them.
Okay.
Because I know your time is limited. We have a 601 area code. You're on the air. Do you have a question or comment for Jeff? If you could, I can hardly hear you. Can you speak up?
I'm sorry. This is Miss Debbie. Can you hear me now?
Hi, Miss Debbie.
You speak a little louder.
What's up? Y'all okay? Can you hear me?
Is that Debbie?
Yeah. Sorry. My phone's acting up. I just want to say I love you, Jeff.
I love you too. I love you.
We are here, baby. We are here, and we'll see you soon. You know that.
Thank you so much for the call.
Welcome.
We're going to go to another call here. We have a 901 area code. You're on the air. Do you have a question or comment for Jeff?
Yeah, I do. I have a question. Jeff, were you blindsided on this, or did you have any clue, or did you ask your attorneys if they could, find this evidence, or were you just, like, clueless during the trial?
Well, I was initially I was shocked when it all came down. It was probably a couple of days before it actually sank in where I was at and what the accusation was, and it was probably a good 3 or 4 days. My initial court appearance, I guess, when it finally came in, but I was hugely naive, and I think my family was for the most part too, because there was that sense that, hey, I know good and well this didn't happen. How can a jury convict me of something like this? I mean, and you hear the horror stories from shows on TV or news or something, and it's one of those things like, oh, that never happened to me, or but there were times, I tried to be proactive in defending myself, and it was hard to do from the county jail. I mean, you couldn't even see outside. You just knew if it was day or night. See, I didn't really have a whole lot of access to do something. I would get every law book I could get and read and try to understand what I was dealing with and the charge and the nature of it. And it was way over my head, but I tried. And I'm a lot further along than I was then. I am now, but I'm a lot further along now than I was then. I'm sorry, but I told my lawyers back then. I said, look, this all comes down to this, and I had this autopsy report, and I was just, saying, hey, we need an expert. Go talk. And they were instructed by the court to go talk to this very medical examiner, and they didn't do that either. And we see what he had, and it's just, I mean, there was a lot of naive, going on, but and it was just, and by the time the trial got there, and it was hugely overwhelming, sitting there at the middle of the trial, and it was just, I think I've described it before like a deer in the headlights kind of a stance, I guess. And by the time it hit me, and here I was up here, and in for the fight of my life. But yeah, I hope that kind of gives you a full complexion of the mood and just the anxiety behind the whole thing.
Just can I get one more question in? How much time do you feel? I mean, do you feel like you had adequate access to counsel? Were you in jail or were you out during your?
No.
While you were preparing for your trial.
No, ma'am. The night that this happened, the very night that this happened, I was placed in a car, sheriff's car, and I wasn't out after that. I didn't even get a bond because of the capital nature of it. But yeah, I haven't been out, and my access to the lawyers, there wasn't. Most of the correspondence was there at the jail because they were there pretty much, I guess maybe a couple times a month or something, or maybe once a month or something. But I largely relied upon trusting in them and the system. And but now I've gotten a lot better access and a lot better lawyers here, which is kind of backwards, from the way due process is supposed to work. But it's been I've got better access now, and I've got a lot of people that actually are on. There's this team that helps my lawyers also, and it's just it includes a lawyer and very close people to me that actually it's just a very fluid and a very dynamic. Information sharing and just, making sure certain things are exposed from the record, as facts as they are, as they appear.
Okay. Well, thank you. We're really pulling for you out here.
Thank you so much.
Thanks so much for the call.
Okay, bye.
Jeff, I know your time on the calls are limited, so if you do run out of time, call us right back because we do have more people on hold.
Well,
we are going to take another call here.
Okay, all right.
It's a 217 area code. You're on the air. Do you have a question or comment for Jeff?
This is Bill Clutter. I'd just like to tell him to hang in there, and there will be light at the end of the tunnel.
Jeff, this is Bill Clutter from Investigating Innocence.
Right. Thank you, Mr. Clutter. It's been a while. I need to quit procrastinating and write you a letter soon. But thank you so much for staying on top of this. And
Jen updates me, so I'm I just follow her Facebook, and I know you've got some great advocates working for you.
Bill actually did some great stuff in this case, and he found he went out and got some affidavits from some experts, and he's done some good work in this case, and I know we're all grateful to you.
Outstanding work.
Bill.
Well, if there's more to be done, we're here for you.
Yep.
You're reading my mail. Exactly. That was exactly what I was going to say, that I think there's more things to be found out in this trial. I think there's more to be uncovered, possibly. I mean, maybe there is or isn't, but yeah, I think more things are going to start coming out.
Well, and it sounds like you're turning a corner with having now Dr. Haynes coming out and saying, I didn't agree with the testimony of these docs when they said this was sexual abuse.
Exactly.
I mean, that's huge, and that should win you relief. I mean,
yes, sir. And on top of that, it couldn't have been about a question of competing opinions, because there was only one opinion that mattered, and this guy he had no opinion about it. Matter of fact, he didn't see any evidence of it, he says. So, in that right there, that there was no other. And keep in mind, this medical examiner was reviewing the evidence that came directly from that ER. So even despite all of the accusations and supposed findings or facts, they weren't there at autopsy. We all know it wouldn't heal or disappear. So, I mean, and Mr. Clutter, it was it wasn't a malicious thing by the ER staff. It was a chaotic moment, and it was just they were trying to save her life. And I understand that, and I hold no ill will, but I just wish that more caution would have been exercised. I understand it was a hugely emotional thing, and it was.
It's the forensic pathologist's job to determine
Correct.
that also.
Correct.
I mean, the microscopic slides and you couldn't ask for something more prejudicial to make an allegation.
6 seconds.
Yes, sir.
left on this call.
Well, there's my warning bell there for 1 minute.
You
so
can
I'll
call back in a minute, and I'll put you through again,
Okay.
Jeff.
Well, you go ahead and keep talking. I'll listen.
Okay. Yeah, but Mr. Clutter, it's I think you may have heard me at the beginning. It's so frustrating that the very words, the very things that have been divulged, in here recently in this recent affidavit and this recent article, that would have been enough for me, that would have been the case that day in the courtroom, and it was obviously classified information because we sure never knew anything about it, and that trial judge sure didn't know anything about it.
But the prosecutor did.
Yeah. Wow.
10 seconds left on this call.
There's no confidence in this verdict period now. I mean, here's the proof. Okay, I'll call
Jeff,
you right
call
back.
right back.
Okay.
And
That's good.
I just want to point out that, like Jeff was just saying, that this is a situation where Jeff was absolutely faulted from the very start for not being able to explain the anal injuries. They asked him over and over again, and they argued in their closing argument, ladies and gentlemen, he can't explain the anal injuries, these horrific anal injuries that existed. Well, he couldn't explain them because they didn't exist, and the state's key expert witness knew that, and they didn't say that to anybody. So Jeff, it was literally in an impossible situation because he could not give them the answers that they were looking for because they were mistaken about the state of the evidence. And we've now got two experts, Dr. Lorison and Dr. Hayne, who have both looked at these tissues under a microscope. There's no injury. We've got 5 experts that have all come forward and looked at the head injury and said this child wasn't shaken. So why the state is continuing to fight this when there's nobody, there's literally, Dr. Hayne says that his conclusion that she was shaken to death was probably wrong. That's his opinion. And 5 other experts say she was not shaken. There's nobody left to say she was shaken to death. There's literally nothing left.
Go ahead, Lori.
You're saying that that they're fighting this, that the state is fighting this. And that's absolutely the truth. Instead of looking for the truth and admitting they made a mistake, they're defending a conviction that's totally invalid.
Completely invalid. It's a factual untruth, and they've been factually untruthful throughout the trial and the post-conviction. They've said 17 times in post-conviction that Hayne concluded the child's anus was penetrated, by an object. That's not true. It's clearly not true. And
it's repeating the same lie. Bill, did you have something to touch base on?
Just keep up the advocacy. I mean, I think that shining as much light on the case as you can, ultimately will get people the support growing, and I think it's great what you're doing.
Well, you're doing outstanding work. I recommend everybody, while we're waiting to get Jeff here back on the phone, to visit Bill's website, investigatinginnocence.org. They were big with the David Cam case and a recently successful case. Jeff's case is featured on their website. They do fantastic work. So please visit that website today, investigatinginnocence.org. And Bill has years and years and years of unbelievable work in the field of wrongful convictions, and we need a lot more people like him because Jeff needs people like Bill.
Thank you. I appreciate those words. We're currently working on a similar case. It's Billy Bob Thornton's daughter who was convicted in Florida. The same type of allegation. A child dies in her care, and there was evidence of a chronic subdural bleed. And there's so many of these cases out there. That's the unfortunate thing.
And now, is that case highlighted on your website, or is that one you just took?
It will be. It's something that we have an investigator in Florida who's a member who's doing some of the post-conviction investigations. So we're looking forward to getting into that case.
Sounds good. We'll have to keep up with it.
We still need you on our case.
Oh, he's not going anywhere.
I know.
Hello?
I love Mississippi.
I can hear Jen trying to hook up Jeff real quick here.
Okay.
These are the interesting things when you're trying to bring people like Jeff on the air, but it's fantastic to have him on, and I know he appreciates talking with everybody.
So, somebody had a question on the internet about why
Oh, you there?
Jen thinks that Hayne is finally being so forthcoming with the truth after all this time. Jeff was tried in 2002, and Dr. Hayne was basically a member of the prosecution team until 2008. So his little bits and pieces, just have come forth so slowly and so little, and then finally, bam, we got the article through Jerry Mitchell, and it kind of broke everything loose for him, and hopefully this is what we need to get him home.
Sure, Jerry Mitchell has done fantastic work as well. Somebody who was bringing attention to this case long before anybody was even talking about Jeff. Jerry Mitchell was investigating this case. And if it wasn't for the investigative work he's done for his articles, we wouldn't have this hope that we have today, because the information that came through in his articles are what are being presented in these motions from the defense.
Jen, why do you think prosecution is clinging to this conviction? Why are they not confessing error in light of what Dr. Hayne is now saying?
I think, that's a sort of the $64,000 question. It happens a lot in cases of wrongful conviction. I think that prosecutors, it's a very emotional case. I think that prosecutors that originally got the case truly believed that, this was a case of murder, and, they, for whatever reason, simply didn't listen or didn't really trust in the opinion of their expert, and they've just sort of clung on to it, that's what they've always believed, and they've sort of convinced themselves of that. And there are cases where, in the face of DNA evidence, prosecutors just refuse to believe that they've been wrong the whole time. I think Jeff is on here right now.
It's hard to imagine, any appellate court, taking a blind eye to all this evidence.
Right.
That's the shocking thing.
Well,
I can understand why prosecutors, refuse to budge in their belief, but you take an appellate court that's supposed to be neutral.
Right. Exactly.
We have a few calls holding, so I'm going to go ahead and take them. They probably want to talk to Jeff, but we're going to get them in because we won't have time to get them all in anyway. So I'm going to go to a 502 area code. You're on the air. Do you have a question or comment?
Hey, Bruce. This is Bob Owen. Hey,
hi, Bob. How are you?
I'm doing well. My question was actually for Jeff, and obviously I wanted to join the chorus of everyone articulating support. And I was curious about something, and maybe when he gets back on, someone can ask him if it makes sense. To what extent do his fellow inmates know about his case, and is it generally understood by his fellow inmates, or have been recognized by his fellow inmates, that the guy's innocent? I mean, he talked about the sensitive nature of his of the charges against him, and that's what a horrific run to have to go to prison under those charges, right? So I'm just curious, has his life in prison changed at all, as a result of the developments in the case?
Can I interject here?
You sure can.
I speak to Jeff. Well, Jen does too, but we speak to him daily. And the thing that Jeff has had to remember over the past 12 years is that those are not his peers. And, he speaks about his innocence. He doesn't really make a big issue of it. You can't do that there because of the jealousy. They all saw the Clarion Ledger article, and he has not gotten a lot of flack from it. He's gotten more positive reaction than he has slack, but people tell him, "Oh, you're going to be walking out of here. You're going to be going home." Although he's so hopeful, he's almost afraid to believe that, and he's afraid to believe that people are sincere because he feels like I know of at least two inmates that show jealousy, and they don't out and out say it's because of the standing of his case, but their relationships have changed in the past few weeks, and it's become more hostile. But he's
also be noted that
tempered.
Jeff's conversations are very limited. We're talking about whoever he can talk to within his cell block, because unfortunately Jeff spends a majority of his time in his cell. I mean, he's in there almost all of his time unless he's taking a shower. So unfortunately, his communication in the prison is limited. I don't think we can get a really good impression of what people think there, because he's only talking to the people that are within voice distance.
Well, they're all kind of within voice distance on death row. There's a lot of screaming and hollering going on, so they do kind of make themselves known.
Yeah. Just to let you guys give you an update, Jeff did just call back, and I could hear him clearly, and then it just did it again. So I told him if we lose him to try and call back, and we'll try and record him, and maybe we can play that for the people that wanted to hear what he had to say, and so hopefully he will do that. But
sure. I'm glad we were able to have him on for the time we did, too, because I know connecting with him can be difficult. Sometimes he calls 3 times before our calls actually go through. I know Jen and Lori have a lot more experience with that than I do, but it's very tricky to hook up to their phone system. I am going to take another call here. Thanks for the call, Bob.
Thanks for taking me, guys.
We're going to go to a 302 area code.
Hello, my name is Sandra Joy. I'm calling from Wilmington, Delaware, and I wanted to offer my support to Jen and Lori. I think that you guys are doing a fabulous job with Jeff's case. I've been tracking all the hard work you've been doing, Jen, as you know, on Facebook and your travels down there. And I think that, the question that was just posed earlier about why isn't the prosecution willing to look at their mistakes is, it's a good question, but it's not really a surprise that they're not willing to look at their mistake. I mean, they're part of the whole corrupt system, right? Whether it's the prosecutors, whether it's the judges or the police precinct. We have a case in Wilmington, Delaware, and this is one of many cases. Jeff's cases are all too often. My friend Jermaine Wright on death row in Wilmington, Delaware, is similar. He had his death sentence overturned in 2012 by a judge who deemed it constitutionally infirm. He was convicted simply on a false confession. He was high on heroin, and the details of the alleged murder that he committed didn't even line up with the actual facts of the crime, but yet he sits on death row in Delaware for over 2 decades now. He just had another unanimous vote against the Superior Court to have his sentence overturned and won a new hearing, and instead of letting him go, the state is now pursuing a new trial for him when he's most certainly going to win. So they don't want to admit fault. I mean, it's that simple. We have to put it in the
that time and time again.
I know, exactly. I think that social media, Jen, you're doing a fabulous job. All of you guys are getting the word out. I mean, I'm down here in Delaware. I'm going to help you get the word out as well, because we need to call them to a level of accountability. The only way we're going to get them to admit their error is to demand at a massive level across the country that they own up to the mistake. But we shouldn't be waiting for the good graces of the prosecution and say, oops, I made a mistake.
Hey, we're screaming as loud as we can.
Thanks so much for the call.
Yeah, no, thank you for what you're doing.
We're going to go to a 706 area code. You're on the air. Do you have a question or comment?
Yes, I have a comment. My name's Tyler. I learned of the case through Jeff's sister, Paige, which we're actually sitting with right now listening to the show. And we just want to say that we know he's innocent and he will be home soon, and we look forward to meeting Jeff.
Well, thank you very much. I know we have Paige on hold currently. I was trying to keep her call for Jeff when he gets back on the air. Thank you so much for the call, and we'll hopefully have Paige on here shortly. Hopefully we can get Jeff back on soon. Jeff's website is freejeffreyhavard.org. We've worked to put everything on that website detailing the case. You can find all of the court documents, the recent affidavit filed by the defense from Dr. Stephen Hayne. You can look at the recent rebuttal that is on the website as well. And we've also linked Jerry Mitchell's article right there on the home page, because it's an outstanding article, and I hope everybody can show some support for Jerry Mitchell. Unfortunately, with the Ledger, sometimes the articles don't stay online forever, so if you do see that article, you might want to cut and paste it on your computer just for personal use, because it's an outstanding article to keep as a reference.
I would like to see everybody show support to Jeffrey by calling the office of Jim Hood and asking the specific question, why is he defending a conviction instead of seeking the truth? And I have a phone number here for Jim Hood if anyone would care to take it down. It's area code 601-359-3680. I mean, the fact that they have every evidence that no crime occurred here, yet they're holding on like a pit bull with a bone. We have to start shouting out about it, and I think a good way to do it is to start with calling Jim Hood's office and expressing our displeasure. Jam up their phone line.
Just be polite about it. We want to be professional in everything we do.
Absolutely.
As much as we might want to scream and shout, we need to be professional.
I think at the very least, I mean, what I'm looking at here with all of these appeals is, you know, we've made some allegations that the prosecution had full knowledge that their expert didn't think that the crime they charged had actually occurred, and we haven't seen the state actually deny that they knew that. We had filed a motion, you know, a while back for the state alleging that they had withheld some other evidence, and they had filed, you know, a response, and they had an affidavit from their prosecutor saying, you know, oh, we turned that over. We don't have any paperwork documenting that, but we turned it over. Well, we didn't even get that in this case. We just got a response from the state that said, you know, to allege that we withheld evidence based on some quotes that you read about in a newspaper, that's not sufficient evidence. So we went out and we talked to Dr. Hayne, and he said, yeah, you know, I swear under penalty of perjury that everything that I said to Jerry Mitchell was true. And all of those same allegations that were in the newspaper were the allegations that we made in our original filing, and the state hasn't addressed any of them. They haven't said, well, you know, we didn't know, or, you know, that's for whatever reason. So I think that speaks volumes, and I think that at the very least, this case needs to be looked into. I mean, how can it happen that you've got a man sitting on death row and the star witness for the prosecution didn't think not only that he was guilty, he thought he was innocent, but he didn't even think a crime committed. I mean, that's just, wrap your mind around that. That's where we're at, and he's been there for 12 years. I want to point out also that our most recent, before all of this, our most recent appeal or post-conviction filing to the Mississippi Supreme Court was based on some statements that Hayne had made at a deposition, where that's where we first got some kind of inkling that something was going on. And the Mississippi Supreme Court basically ruled in its decision that, you know, there's no evidence that, or there's been nothing alleged that any of Dr. Hayne's statements regarding his opinion were not discoverable, that we couldn't have found it at the time that Jeff went to trial. And the bottom line is that Jeff's trial attorneys filed discovery motions. They asked for all, you know, exculpatory evidence. They asked for all reports, all statements, oral, everything that exists regarding the opinion of their experts. I mean, I think it's fair to even, you know, anybody that doesn't know anything about the law, that you get to know what the expert thinks happened. And they simply didn't turn them over to us. So we thought they did, or I keep saying we, Jeff's legal team, you know, that long before I ever heard of the case, they thought that everything had been turned over, because that's what the prosecution is required to do. They're required to answer your discovery. They're required to be honest. They're required to give you everything that they have. And they did. They gave them everything that was in paper. And they gave them an autopsy report that said nothing about sexual abuse. And they just talked about it amongst themselves. And that is, quite frankly, it's a fraud. I mean, there's no other way to put it.
Jen, there's a question here on Facebook from the Mississippi Supreme Court ruling. I know Oliver Diaz was part of this. They ruled 7-2 against Jeff. Was there a minority opinion published that's public?
There was not. There was not. It was a full court, and two of the justices had dissented. That you're talking about the 2000. That was either the direct appeal or the first post-conviction. I can't recall which one.
Right, this is long in the past. I mean, this is before all of this new evidence and new information came out.
Correct, and I should point out that the first attorney that Jeff had, and we're talking about his trial attorneys, and he gets another set on his direct appeal and another set for post-conviction. The attorneys that he has right now, they're the first attorneys that actually went out and sat down in 2009 and when they got the case and spoke to Dr. Hayne, and said, why didn't you include sexual assault or that you saw evidence of that in your autopsy report? And that's when Dr. Hayne slowly started to reveal, I couldn't really come to a conclusion and so forth. So from 2002, from the time Jeff was convicted until 2009, nobody had any idea that there was even a question in Dr. Hayne's mind that, that was his opinion. So there you've got it's ineffective assistance of counsel, obviously, to have your attorney that's representing you for your life not do any sort of pretrial discovery. So even if, despite the Brady violations, despite the fact that the prosecutor had to turn all this stuff over, everybody that is facing, prison time or death, God forbid, is entitled to an attorney. And in this case, Jeff didn't get that. They didn't speak to any witnesses, including Hayne. They didn't go to the doctors and find out, how long did you look? And there just was Jeff has yet to have his day in court. And I don't know if Lori and I were talking about this earlier, if you want to chime in on that.
Well, he didn't receive due process. Everybody in the United States is entitled to due process. His attorneys did no investigation, no independent investigation. They relied on the information that was given to them by the state.
Right.
They called one witness on his behalf. Now Jeff's calling me, except I can't connect him.
I don't know. Yeah.
I can't connect him. And he's been locked away ever since, and he's never been in a courtroom. He's never been out off of death row except to go to visits. He deserves, his grandmother and grandfather come and visit him every 2 weeks. He's allowed 2 visits a month.
That's when he gets out of his cell. That's not when when he's off of death row. Just so everybody realizes that's just kind of
he just gets
down
out
the
of
farm.
his cell.
Sure.
Right. Sorry.
Well, unfortunately, we are restricted by time here tonight. I know we could talk about this for hours, but I'm going to go ahead and put Jeff's sister Paige on. I was hoping we could have her come on when he was on the show, but we only have so much time. So, Paige, welcome to the show.
Hello. Hi, Bruce.
Is this Paige?
Yes, it is.
Hello, Paige.
Hi, Bruce.
Welcome to the show.
Thanks for having me.
Sure. How you been?
Good, thanks.
Hi, Paige.
Hi.
It's Jen.
Hi, Jen.
Hi, honey.
Hi, Lori.
Hi.
Sorry to keep you on hold for so long, but I was trying to put you on the air when Jeff was on, so we were trying to hook that up, but unfortunately it didn't happen. So are you optimistic as well about the recent developments in your brother's case?
Yes, I'm also excited because they have no choice but to give him this hearing, in my eyes.
That's what it looks like.
There are some,
Sure, come a long way in a year, huh?
Oh yeah, absolutely. Thanks for all the help. Yeah, I'm definitely optimistic. I don't understand why they can't just do the right thing before they wind up.
Hopefully they still have a chance to. I mean, you never know. This new claim was just filed, and I'm hoping that based on what's out there now, somebody needs to really take a look and say, do we have any evidence left? Why are we pursuing this? How hard is it to just say, you know what? I think in this case we just were wrong.
And they were.
Hopefully that time comes. Paige, your family and Jeff have a lot of support. It continues to grow. So hang in there. Stay optimistic. Say hi to your mom for me.
Will do.
Bye, honey.
Take care, Paige.
Lori had a really important message from Jeff that I just think is so important for everybody to realize.
He wants justice not only for himself but for Chloe and for her family. Like I was saying before, they were told by the people that they were supposed to have faith in, the prosecution, the chief of police, They were told that Jeff committed a crime of a monster, and they've believed that that child died in pain and suffering for almost 13 years. And she didn't. He didn't do what they claimed to that family that he did, what they claimed to the world that he did. And I don't know
nobody
how,
did.
Right. And I don't know how that family is going to wrap their head around this. I don't know how they're going to be, because understandably a child was lost. But there was no intentional crime. There was no assault on her. None of that. It's all falling apart. It's all crumbling. And it's so much of an issue to him, not only that he gained relief, but that they know what the truth is. And I'm hoping that they're listening, they're seeing, they're watching, and they're understanding that this is not just a bunch of supporters making up stories. This is the real deal. He did not do this.
And nobody did this to...
Right. There's no crime committed. It's very clear now. Hopefully this new rebuttal, this new information is finally heard. I want to thank everybody for calling in tonight, especially Bill Clutter. Thank you for calling in. We appreciate everything you do. Jen, as we wrap this up tonight, what are we looking at here? Do you think the state will have no choice but to accept this and actually change course? Or do you think this will end up in federal court?
Oh, God, the state always has a choice, and so does the Mississippi Supreme Court. But I think that the time has come that it's been painfully slow in accumulating and sort of it's been pulling teeth in getting bits and pieces of information to get us towards this truth that, as I've mentioned before, that the state was completely aware of the entire time. But I think that when you boil it down, it's going to be up to the Mississippi Supreme Court. I mean, the state has been, vigorously opposing, even an evidentiary hearing. We just like to have an evidentiary hearing. Let's put some people on the witness stand. Let's find out before, God forbid, we kill an innocent person, before we end his life intentionally. Let's get some testimony. Let's get some sworn testimony and sort of hammer this out. Let's find out what the actual situation was and who said what and who believed what. But the state doesn't want to do that. The state says, you've had your appeals. You should have asked, the state actually said that Jeff's trial lawyers should have asked more detailed questions when they had a chance to, when Dr. Hayne testified at trial. They didn't, so sorry. And that's just not, that's not a civilized way to handle things, of course. The Mississippi Supreme Court can outright grant a hearing that we're asking for. They could conceivably, even though we're not even asking for it, flat out vacate his conviction. I mean, stranger things have been done. That recently happened in the Michelle Byram case. Or they could deny all relief, and we'd be back in federal court. But I just think that more and more just seems to be coming out every day, and it's literally with every few months that pass, we're learning more. And, the truth is here. It just depends on who wants to see it and who is interested enough to take a look. I hope the Mississippi Supreme Court is. They seem to be moving in that direction. They seem to be realizing that there's some kind of a problem going on, and several...
So there have been recent cases that came before the Supreme Court that have been overturned, or at least new hearings have been granted, correct?
Well, there's some cases where, like I had just explained, that short of overturning the trial, they can grant what's called an evidentiary hearing, which is where you actually, instead of arguing before the court, you bring in the witnesses. You put Dr. Hayne on the stand and you say, when you testified, why did you say this? And you get to the bottom of the discrepancies, and they've granted some of those. Michelle Byram, they vacated her conviction, and she was within, a day maybe?
No,
a day of being executed?
Overturned her conviction exactly 1 week to the day from the day she would have been executed. So 1 week later, after her execution date, they granted her relief.
Right.
That's just
right down to the last week.
Yeah.
Right.
No,
and it does show
after.
that the Supreme Court doesn't always turn a blind eye. They will look at the cases. So with this new information, we do have reason to be hopeful that they'll do what's right.
You always have to hope that they're going to do what's right. It's a matter of, is the truth getting out? And I think it finally is. And so we haven't, the problem is that although Jeff has had 3, different types of either motions or petitions that go to the Mississippi Supreme Court, we haven't had the hidden information to give them. I think that there are numerous other issues that could overturn his conviction, but this is just it's gotten to the level that now it's indisputable. I mean, I don't know how you can look at it otherwise. And the Mississippi Supreme Court is going to decide one way or the other what's going to happen in this case, and that could be, a few weeks from now, or it could be a year from now. There's no telling. So we can only just try and keep getting the information out there because, this is a death penalty case, and the public certainly has an interest, and they should be concerned.
People need to speak up about the case. Tell your family and your friends about the case. Inform people to visit freejeffreyhavard.org. Facebook is an excellent tool for communication, so definitely get involved in this case. Search Jeffrey Havard on Facebook. You'll see the pages that are dedicated to him.
We have we have every document. We have every piece of paper. I'm happy to answer any questions anybody has. The best of my ability, and we're gonna do other podcasts, and we have some from previous times that are going to be available on Jeff's website if anybody's interested.
And I do apologize we couldn't get Jeff back on, but those are just the realities of what we face here. Trying to hook up a phone conversation with a man on death row in Mississippi is not easy. But I'm very happy we were able to have him on for 20 minutes. I know he appreciates the support greatly. I know he enjoys hearing people talking about his case, so thank you for everybody that called in. I don't speak for Jeff, but I can speak for this. He definitely appreciates all the support that he gets from everyone. I want to thank you both for the show tonight. You guys both did fantastic as always, and we will continue discussing this case and keep fighting for Jeff for as long as it takes.
Thanks, Bruce.
Thanks.
Take care.
Please visit injustice-anywhere.org. That's our main website for up-to-date information on our future shows. I'll post up information for next week's show right there on the homepage. And once again, please visit freejeffreyhavard.org to learn more about this case. Thank you again for tuning in. Good night.